I'm delighted on the programme Save the Nation to have probably the nation's leading legal commentator in all parts of the media and also Vice President of the Rule of Law Institute. Welcome, Chris Merritt.
Hi, how are you?
Good. Well, Chris, you say, you're on the record, you've been published and reported as saying that diversity must be irrelevant when we are choosing judges. But before we discuss that, I'd like you to see this.
Choosing someone to sit in the Supreme Court, I believe, is one of the most serious constitutional responsibility a president has. Our process is going to be rigorous. I will select a nominee worthy of Justice Breyer's legacy of excellence and decency. While I've been studying candidates' backgrounds and writings, I've made no decision except one. The person I will nominate will be someone with extraordinary qualifications, character, experience, and integrity. And that person will be the first Black woman ever nominated to the United States Supreme Court.
Now, Chris, has that got you to change your mind?
Surprisingly, no. In fact, it encourages me to argue even in stronger terms that diversity is the devil's work, at least when it comes to judicial appointments. It mistakes the role of the bench. It might be completely different in the United States, where the Supreme Court quite obviously is politicized. But in this country, we don't elect judges. They don't have the same role in politics that the US Supreme Court has. And therefore, in order to protect our judiciary from the same sort of partisan appointments and abuse that takes place in the United States, I think they should be selected on one criteria alone, and that's merit. And that's the ability to do the job regardless of whether a judge wears a dress or trousers, and regardless of the colour of their skin, which, look, diversity might be a wonderful thing to pursue in other fields of endeavour, but the judiciary is there to do a job. It's not there to represent any particular group by race or background or gender or politics. It's there to impartially apply the law. And generally, that law should be made by Parliament, not the judiciary. Once we change from that or differ from that, we start to assume some of the principles that underpin the American system, where the US Supreme Court makes decisions on matters all contained in their Bill of Rights, which are innately political. We don't have a written Bill of Rights, and therefore that political role is not imposed on our judges. They're there to do a relatively modest role of applying the law. The American judges on the Supreme Court are there to give meaning to broad general terms which are outlined in their Bill of Rights. So inevitably, that will be a political task, and that explains the importance of political considerations, at least in the eyes of the US president, when it comes to judicial appointments. That's not a path we should go down.
I think you're right. I don't think that was the intention of the founders. I think the intention of the founders was to establish a court similar to the British courts. But they have unleashed a monster there, and I think that decision taken before the Civil War, which is Dred Scott, which is regarded as probably in many ways triggering the Civil War, just demonstrates, I think, how dangerous it is to have a politicised court. Did you detect something of a politicisation sometimes in some of our cases? For example, in the appeal by Cardinal Pell to the Supreme Court of Victoria, I thought that two of the judges were very much influenced by the then current catch cry, that is, believe the victim, and they seem to be applying that rather than the basis of the criminal law, proving guilt beyond reasonable doubt. And I thought that the third judge, who had a criminal law background, seemed to be the one who seemed to know what the law was. That was my impression in that case.
Look, I think you're right, and I think it's part of a tendency which is growing, where authorities, particularly the police, but you hear it in courts all the time, where complainants, particularly in sexual assault matters, are referred to, before any finding of guilt against anybody, they're referred to as the victim, and the person charged with an offence is considered to, or referred to as, the perpetrator or the offender, which is, and you see it in police press conferences, you see it in the media, quite frankly, and it's a lesson for the media, I think, particularly given the outcome of some of the cases. One particular case I'm talking about, which is the Brittany Higgins-Bruce Lerman matter, which is never going to be resolved. It'll always be a case of an unproven accusation, despite the fact that some parts of the media, initially at least, believed the woman before any court had made any determination.
Yes, I agree with you, and the idea of having a representative judiciary is, I think, ridiculous. I was looking up some statistics last night, and I found that of Australians, 0.24% are prisoners. Well, there be a representative prisoner, former criminal, among the judges? Should that be a requirement too? It just is so ridiculous.
Look, it's the sort of thinking that would appeal to politicians. Politicians could see an enormous, or some politicians could see an enormous advantage in doing what the Law Reform Commission has recommended, which is start assembling statistics on judicial diversity. The only possible reason for doing that, in the eyes of a politician at least, would be to provide a benchmark for future appointments based on race or gender or some other personal factor, rather than the ability to do the job, merit. So I think our government, our federal government, should be quite careful when it comes to pushing ahead with their commitment to start measuring judicial diversity, because the natural consequence is to change over time the criterion for appointment. This will happen in reality regardless of whether the formal criterion remains merit. The political imperative will be, well, what do the statistics say? Have we got sufficient blue-eyed judges from Newcastle? We better appoint a few more. It's silly if you think through what the role of the judiciary is.
Do you think, just looking at the High Court, for example, the fact that I don't think we've ever had a judge from South Australia, is that not right?
I think that's right. I think that's right, yes.
A criticism, I think, can be made about the High Court is that they do tend to appoint from the Sydney and Melbourne bars, because the leading constitutional lawyers, I suppose, tend to be in those bars, but you then get a particular view of Australia.
Look, I think that's quite right, and it probably explains, if you think it through, why Section 92 of the Constitution no longer means what it says. Trade, commerce and intercourse between the states is not absolutely free, regardless of what the words of the Constitution say. You do tend, it's unarguable that you do tend to get an East Coast view of the world. I think the the people of Western Australia would, after their shocking experience during the COVID pandemic, where they were effectively locked up for the better part of 2 years, they'd take a different view of Section 92. And I feel sure that Clive Palmer, who tried to strike down that state-based barrier and implement the plain words of the Constitution, he'd take a different view as well.
Yes, there are provisions, aren't there, in the Constitution which don't seem to mean anything. For example, Section 100, which provides guarantees the reasonable use of the rivers to residents and states, and that's been completely overridden using the external affairs power and the fact that the Commonwealth has entered into treaties in relation to environmental matters, which seems to override a very clear provision in the Constitution, which took some weeks to work out. And I think it was Alexander Downer who worked out the compromise at the convention in Melbourne, not the present Alexander Downer, but an ancestor. Chris, you've been very generous with your time because I know you're very busy, but the Rule of Law Institute is a very important body, and all of your comments do appear there, do they not?
That's quite right. Yes, they're all online.
Well, thank you very much, and thank you for the time that you've spared for us for today. It's very important that to get these messages out and for people to understand them. Thank you.
Quite all right.